All right, welcome back. It's been a little while. Sorry about that. Let's see if I remember how to do this. So yeah, I had a great vacation with my family. Went with my parents and my sister and her husband and son and my cousin and her family, and then my sister's friends, and ran the Snake River just outside of Jackson Hole, Wyoming. We've been doing that. Well, my family's been doing that for 50 some years, so longer than I've been around. Had a great time, and I mean, I even brought my computer, brought my old microphone, thinking, well, maybe I'll find some downtime, but I didn't, and the internet in the cabin sucked anyway, so what are you gonna do? But I- I've been home and just haven't been able to get back on my normal schedule since vacation, so sorry about that. But I'm here. Hopefully, this is the kick in the pants I need to get caught up on the backlog of everything that predates my vacation. So, uh, that being said, let's jump into it. So today we are sticking with Decastro versus LVMPD, and I don't actually remember exactly where I am on this. So let's uh, let's scroll down in the docket, and the last video I did was Delete Lawz opposition to the motion to dismiss, the opposition to the 12b6, and the reply in support of the 12b6 by LVMPD. So I know that's the last I did, but I can't remember this is going back all the way back to the Jason Jensen nonsense, but uh Delete Lawz, when he did his motion to have the federal court force the state criminal court to put the criminal case on pause, to issue a stay of the criminal case. And I know I covered that, but I don't think I did his motion to reconsider or the response to that. But whether I did or didn't, I'm just that's so far in the past and I don't care about it, so I'm not going to do it. Uh, you know, it's my channel. I'm going to do what I want. So basically what I'm going to do is starting on docket 31, I'm going to move my way forward, but I'm not going to go in order. I'm going to kind of group them into, a motion and the response to that motion. And so do them in groupings like that and go from there. So just looking at the docket though. So like I said, I'm starting with 31, and that's the summons returned executed by Jose de Castro, state of Nevada served. And this is all the way back to June 23rd. Sorry about that. And then we have the motion to stay discovery by LVMPD. And then we have an answer by LVMPD. Then we have a response to the motion to stay, and then an order on it. And then we have a motion for entry of clerk's default by Delete Lawz against the state of Nevada. And then a motion to partially strike defendant's answer by Delete Lawz. And then most recently, today, we have the response to that. So, like I said, we're going to start with the summons. And oh boy, this one is hilarious. It gives me great joy. Why does it give me great joy? Well, this document, it's just the return of the summons. It's a formality, kind of. And this is what gives me great joy. The fee for service was $225.70, paid by Delete Lawz, or I guess more specifically by his supporters, all three of them. And he served the state of Nevada. Specifically, he served Sandra Guillard, legal office manager, served under FRCP Rule 4 at 100 North Carson Street in Carson City, Nevada. Served by Tony Ruckman of Washoe County. And signed by the same, Tony Ruckman. Now, why does this give me such joy that he spent $225.70 of his followers' money serving the state of Nevada? Well, it's a little thing called the 11th Amendment of the U.S. Constitution. And the 11th Amendment reads, "The judicial power of the United States shall not be construed to any extent, shall not be construed to extend to any suit in law or equity," because, the Constitution was written when there were courts of equity and courts of law. They were merged in the last century. So law is you're asking for money. Equity is you're asking the court to do something. So like a restraining order would be an equitable relief. So it shall not construe to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Well, let's see. Against one of the United States. Nevada is one of the United States. Delete Lawz is a citizen of another state, specifically California. How do we know? Well, at the risk of doxing him, his address on the proof of service. On the proof of service of the state of Nevada is Santa Monica, California. So, whoops. Of course, it's basically been extended. I can't sue the state of Utah. Although there are ways around it, kind of, but I'm not going to give any hints. But Delete Lawz, unaware of the 11th Amendment, applied to the clerk of court for an entry of default against the state of Nevada. So let's take a look at that. To the clerk of the United States District Court for the District of Nevada, Plaintiff Jose Decastro hereby requests that the clerk enter the default of defendant state of Nevada for failure to plead or otherwise defend in a timely manner as provided by Federal Rules of Civil Procedure Rule 55A. This request is based on the following. 1. The defendant was served with the summons and complaint at ECF number 13 pursuant to Federal Rules of Civil Procedure Rule 4C on June 23, 2023, as evidenced by the proof of service on file with this court at ECF number 31. 2. The defendant has failed to plead or move for further time to plead or otherwise respond to the complaint. 3. The applicable time limit for responding has expired. Declaration of Jose Decastro in support of entry. I declare under penalty of perjury that the foregoing is true and correct. Dated July 22nd, 2023. Submitted Jose Decastro, pro se plaintiff. Well, unfortunately for him, the state of Nevada is completely immune. The court lacks subject matter jurisdiction for this case against the state of Nevada. I mean, he can apply for a $10 billion default judgment. He won't collect a penny because the state's immune. I mean, you hear about, well, okay, how many times have we heard Delete Lawz say, James Freeman is an idiot. Qualified immunity doesn't matter. We need to overturn Terry versus Ohio. Well, I agree with him. James Freeman is an idiot, but that's beside the point. Well, this isn't qualified immunity. This is sovereign immunity. You'd think a sovereign citizen, which, I don't think Delete Lawz is a true believer sovereign citizen, but he exhibits enough tendencies of a sovereign citizen that I'll call him a sovereign citizen. It's my belief. You'd think a sovereign citizen would understand the concept of sovereign immunity, state sovereign immunity. Unless the state of Nevada agrees to be sued, because they can waive. They can tell Delete Lawz, oh yeah, sure, sue us. Unless they waive, they're immune, period. So good luck with that. But let's move on. So next we have the motion by LVMPD defendants for a stay of discovery. Because, well, despite Delete Lawz thinking that it works the other way, thinking that because he sued in federal court, that should somehow magically put a stay on the state law criminal case, despite the Younger doctrine. Well, the Younger doctrine still exists and it still applies. But to this, because the state case, the state criminal case is still ongoing, this case shouldn't exist yet. So basically, this is LVMPD saying, hey, judge, time out. Let's not spend all this time and money on a case that, after September 12th is going to be irrelevant anyway once he's convicted. So let's press pause. Let's issue a stay on the federal civil case. So let's take a look at the motion. Defendants, Las Vegas Metropolitan Police Department, and the officers, by and through their attorneys of record, Markey Auerbach, hereby file their motion to stay discovery. This motion is made and based upon the pleadings and papers on file herein, the memorandum of points and authorities attached hereto, and any oral argument allowed by counsel at the time of hearing. Memorandum of Points and Authorities. Introduction. Plaintiff Jose Decastro is suing LVMPD, several LVMPD officers, and the state of Nevada, claiming he was falsely arrested and the officers used excessive force. The LVMPD defendants have filed a motion for partial dismissal. That's the 12B6. I know we've covered that. The criminal charges stemming from Decastro's arrest are still active. Trial on September 12th, to be filmed by our Nevada judges. Go subscribe Alex is awesome. This motion requests this court stay discovery in this matter until Decastro's criminal charges are resolved. Pursuant to the favorable termination rule. Oh God. That just gives me flashbacks to Idaho, where Ashley Guillard, well, you know, it what's she trying to counter sue for? The I'm having a brain block. The basically she's trying to sue them for filing a frivolous suit. The vexatious prosecution, or that's not what it's called. Why am I having a hard time thinking of it? Either way, it has a favorable termination as a prerequisite. She says, but she argues, well, they're unlikely to win anyway, so we may as well just get on with it. Not how it works, but either way, pursuant to the favorable termination rule set forth by the U.S. Supreme Court in Heck versus Humphrey. I wonder if my computer just automatically changed that since I'm in Utah. Outside of Utah, that might be Hell versus Humphrey, but Heck versus Humphrey, U.S. Supreme Court, 1994. If Decastro is convicted of the criminal charges, he may be barred from pursuing most or all of his claims asserted in this action. Additionally, the factors provided by the Ninth Circuit in Keating versus Office of Thrift Supervision, Ninth Circuit, 1995, militate in favor of a stay under these circumstances. Lastly, the Younger, footnote 1, abstention doctrine requires that this court stay these civil proceedings while the state court criminal proceedings are ongoing. Let's take a look. Younger versus Harris, Supreme Court, 1971. So I feel we've already discussed the Younger doctrine to death in Delete Lawz motions to stay the criminal case. So if you need more information, go back and rewatch those videos. Give me the view. Oh. Where am I? Okay. Accordingly, this court should stay the instant action during the pendency of the state court criminal proceedings in connection with the same nucleus of facts giving rise to Decastro's claims in the instant case. Because there's no sense litigating the same nucleus of facts twice. At least, well, there might be. There might be. But if basically, I know I've discussed this before too, but hear me out. If he's convicted in the criminal case, that means he committed the crime beyond a reasonable doubt. So there is no point in that case of litigating the same set of facts twice. But let's say he's not convicted. Well, then the question isn't, did he do this beyond reasonable doubt? It's, did the officers have probable cause to arrest him? Which is a much lower standard. So the jury, although I think it's a bench trial in Vegas, isn't it? On the 12th. So the judge could find that it didn't go all the way to the reasonable doubt standard. But that doesn't mean there wasn't probable cause. That's all that needs to exist for LVMPD to win this lawsuit. Facts. The subject incident. On March 15th, 2023, at approximately 4:30 p.m., Officer Bork was conducting a traffic stop of a silver Hyundai Elantra. Decastro approached the traffic stop and began recording and talking to the traffic detainee. At the time Decastro approached the traffic stop, Officer Bork was sitting in his LVMPD vehicle. Upon noticing Decastro interacting with the subject of the traffic stop, Officer Bork exited his police vehicle, got Decastro's attention, and told him to back up. Decastro moved 5 feet. And these are all citing directly to Delete Lawz amended complaint at ECF number 13. Officer Bork again told Decastro to back up from the traffic stop, at which time Decastro began asserting his rights to record the interaction. Officer Bork warned Decastro he would detain Decastro for obstructing if he did not move further away from the detainee. Decastro insisted he had no obligation to back up because of his status as a member of the press and his right to record police interactions. When Decastro ignored Officer Bork's commands to move back 10 feet, Officer Bork told Decastro he was being detained. Officer Bork told the traffic detainee she was free to go. And then, well, no, he didn't argue Rodriguez this time that you can't extend this further, but that's a common tactic of his, a common misreading of Supreme Court case law of his, but we won't get into it since I don't think he did that this time. When Officer Bork attempted to detain Decastro, Decastro refused to comply. Decastro asked for a supervisor and walked to Officer Bork's LVMPD vehicle, at which time Officer Bork informed Decastro he was being arrested for obstruction. Decastro made Officer Bork aware of a prior shoulder injury, and Officer Bork placed Decastro in 2 pairs of handcuffs to adhere to his medical needs. And we saw that he could practically bring his wrists to the front of his body. There was that much leeway in the torture cuffs. Decastro then threatened to sue the officers at the scene. Decastro further alleges he was patted down several times, and during the final pat down, an officer struck Decastro in the groin with a closed fist. I wonder. I'm a terrible musician, but well, we'll just leave it at that. I'm a terrible musician. And I can't remember. Okay. I think Blue Bacon, if you're watching this, Blue, here's my suggestion for you. A fundraiser. The final pat down. Sounds like a good parody to make of The Final Countdown by Europe. I had to look it up. I was going to say Asia, but that was heat of the moment. So Blue Bacon, do it. Do a parody, The Final Pat Down. Eventually, Defendant Erland Jason Torrey arrived at the scene. Sergeant Torrey authorized the officer's behavior as being within LVMPD policy and said Decastro should be arrested. As noted in Officer Bork's report and affirmed by Sergeant Torrey, the reasons why Decastro was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised he was being detained. What do we not see in that list? We don't see, as any of the reasons, filming. Decastro was subsequently arrested for obstructing a traffic stop and transported to CCDC, that's Clark County Detention Center. The criminal charges against Decastro are still pending and active in Las Vegas Justice Court. See Decastro Las Vegas Justice Court criminal docket attached as Exhibit A. Procedural history. On April 17th, 2023, Decastro filed this lawsuit asserting several causes of action based upon his being arrested on March 15th, 2023. Decastro amended the complaint on May 7th, 2023. The gist of Decastro's lawsuit is he was falsely arrested and the officers used excessive force. Despite Decastro's filing of the instant civil action, Decastro is currently undergoing state criminal proceedings in Las Vegas Justice Court in connection with the incident that forms the basis for Decastro's claim. Legal standards. The district court has broad discretion to stay proceedings as an incident to its power to control its own docket, citing Clinton versus Jones, Supreme Court, 1997. Clinton versus Jones is that's got to be Bill Clinton versus Paula Jones. I wonder what that one's about. I bet it's spicy. Which Clinton versus Jones cited Landis versus North American Co. Also Supreme Court, 1936. A stay is discretionary, and the party requesting a stay bears the burden of showing that the circumstances justify an exercise of that discretion, citing Niken versus Holder, Supreme Court, 2009. The Keating factors. When a civil plaintiff brings claims under a Section 1983 that are related to rulings that will likely be made in a pending or anticipated criminal trial, it is common practice for the court to stay the civil action until the criminal case or the likelihood of a criminal case is ended. That's Wallace versus Cato, Supreme Court, 2007. See also Federal Savings and Loan Insurance Corp versus Molinaro, Ninth Circuit, 1989. The decision whether to stay civil proceedings in the face of a parallel criminal proceeding should be made in light of the particular circumstances and competing interests involved in the case. And that's citing Molinaro. When determining whether a stay is appropriate, courts look to whether the criminal defendant's Fifth Amendment rights may be implicated by the civil proceedings. See Keating versus Office of Thrift Supervision, which cites Molinaro. Courts also consider 1. The interest of the plaintiff in proceeding with the litigation and the potential prejudice to the plaintiff of a delay. 2. The burden which any particular aspect of the proceeding may impose on defendants. 3. The convenience of the court and the efficient use of judicial resources. 4. The interests of third parties. And 5. The interests of the public. So, this first one is, of course, the big one. The defendant's Fifth Amendment right. He doesn't have a Fifth Amendment right. Well, kind of. In this civil proceeding. Let's say in some bizarro world, his request to stay the criminal proceeding had been granted. Well, then in this, either he waives his Fifth Amendment, which, let's face it, anything he says in this is admissible in his criminal case under multiple rules of evidence. Because, he may try to argue, well, that's hearsay, but it's not an out-of-court statement. And there are a lot of evidence rules. But like, let's say this goes to trial. He gets on the stand. Either he asserts the Fifth Amendment, but then an adverse inference is given, and so it's basically he's for all intents and purposes admitted the question, or he testifies he doesn't assert his Fifth Amendment, and it's held against him because one of the easiest ways to get what otherwise would be hearsay in, well, if you were subject to cross-examination in court, you just bring the transcript of that straight to the next court and say, here you go. But there's also the statements of party opponents. Well, Delete Lawz is a party opponent, so the state of Nevada gets it in easy in the criminal case, and there, there are a few others too. But so that's why bringing this civil case before the criminal case is over is so stupid. And this is something that really kind of annoys me. It happens it happens both in federal and state court, but the most common way that you see this is with the state or feds as the plaintiff in the civil case. And it really happens a lot in securities cases. So the big one right now is Sam Bankman-Fried. He has parallel cases going on right now where he is being sued civilly by the Securities and Exchange Commission and the CFTC, the Commodity Futures Trading Commission. And he's facing charges in the Southern District of New York. So he's got 3 cases going on simultaneously. 2 of them are civil and 1 well, I think he's got more than 1 criminal, but I can't remember. It's been a while since I've looked. And the feds do that all the time. And it kind of annoys me because it basically makes the SEC case a slam dunk, because you're going to have a whole lot of adverse inferences because he's going to plead the Fifth unless the criminal case is done with. And frankly, it's the same here, except he's the moron that brought the civil case. The feds didn't force him into it. He brought it. And so it, one of the appropriate things to look at is what Fifth Amendment rights would be implicated. So moving on, the Heck standards. In order to recover damages for allegedly unconstitutional conviction or imprisonment, or for other harm caused by actions whose unlawfulness would render a conviction or sentence invalid, a Section 1983 plaintiff must prove that the conviction or sentence has been reversed on direct appeal, expunged by executive order, declared invalid by a state tribunal authorized to make such determination, or called into question by a federal court's issuance of a writ of habeas corpus. And that's 28 USC section 2254 would be, I believe, about writs of habeas corpus, and that's citing Heck versus Humphrey, Supreme Court, 1994. A claim for damages bearing that relationship to a conviction or sentence that has not been so invalidated is not recognizable under Section 1983. The question of whether a Section 1983 action is barred by HEC is more difficult to answer where the plaintiff is facing charges of resisting arrest or similar conduct arising from the same incident. He is claiming excessive force, or if the plaintiff is alleging false arrest or a similar claim. See Wallace versus Cato, Supreme Court, 2007. In such a situation, a stay may be appropriate until such time as the underlying criminal proceedings are concluded, at which time the court would be in a better position to evaluate whether the Section 1983 action would impugn any conviction resulting therefrom. Up next, the Younger abstention doctrine. Absent extraordinary circumstances, federal courts may not interfere with ongoing state criminal proceedings. See Younger versus Harris, Supreme Court, 1971. Although that's exactly what Delete Lawz asked the court to do. A court may consider sua sponte, that's on its own, whether Younger abstention should be invoked at any point in the litigation. That's Gordon v. Koppel, Ninth Circuit, 2000. Abstention is proper regardless of whether the applicant seeks declaratory relief, injunctive relief, or damages. See Mann versus Jett, Ninth Circuit, 1986, which says, when a state criminal prosecution has begun, the Younger rule directly bars a declaratory judgment action, as well as a Section 1983 action for declaratory relief and damages, where such an action would have a substantially disruptive effect upon ongoing state criminal proceedings. And also Gilbertson versus Albright, Ninth Circuit, 2004, en banc, meaning the entire Ninth Circuit, not just a 3-judge panel, which says, Younger abstention applies to actions for damages as it does to declaratory and injunctive relief. And going back, I think Mann versus Jett sounds like a late 90s Fox special with a man racing a jet, of course. I wonder who would win. A court may apply a stay under Younger when 1. The state court proceedings are ongoing, which they are. 2. The proceedings implicate important state interests. They do. The state absolutely has an important state interest in, well, for starters, not spending money on frivolous litigation while the criminal case is ongoing, but also that they have a compelling state interest in the police not being interfered with. No obstruction of official business. That's an important state interest. And 3, the state proceedings provide an adequate opportunity to raise the constitutional claims. That's citing Escobar versus LASD Male Doe, Central District of California, 2017, citing Middlesex City Ethics Commission versus Garden State Bar Association. So that would be arising out of New Jersey, but it's a Supreme Court case from 1982. So this number 3, the state proceedings provide an adequate opportunity to raise the constitutional claims. He can raise, freedom of the press. He can raise that as a defense in his criminal case. It's not going to work, but he can raise that. He can raise these defenses. He can say, Your Honor, this was my First Amendment right to film the police. You can't convict me for that. It's my right. It's not going to work, but he has the opportunity to raise it in the state criminal proceeding. Legal argument. The Keating factors favor a stay. Here, the instant civil rights action implicates Decastro's Fifth Amendment rights. The facts and circumstances underlying Decastro's criminal prosecution overlaps with the civil rights claims at issue in this case. Both cases involved the March 15th, 2023 incident between Decastro and the defendant officers. Thus, if the case proceeds, the LVMPD defendants will seek discovery from Decastro, and he will be required to respond under oath. It's not just in-court testimony. Depositions are under oath. They can be used against you very easily. Interrogatories, the written, they're submitted under oath. They can be used against you. You don't want to sue before the criminal case is over. Unless, of course, I mean, the statute of limitations plays a role, but when you sue 2 weeks later, that's dumb. That's really dumb. The discovery will involve Decastro's alleged criminal actions on March 15th, 2023. Thus, there exists a substantial risk of prejudice to Decastro's Fifth Amendment rights if the case is not stayed. Furthermore, if Decastro invokes his Fifth Amendment rights in the context of this litigation, it may impede the LVMPD defendant's discovery. That's citing Jones versus Conti. ND. Is that Northern District of California? Well, either way, it's from 2005, and it says, findings that a stay of the civil case involving defendant in criminal action was appropriate because if discovery moves forward, the defendant will be faced with the difficult choice between asserting his right against self-incrimination, thereby inviting prejudice in the civil case, or waiving those rights, thereby courting liability in the civil case. Moreover, the other Keating factors also support a stay. Any prejudice to Decastro is minimal, given that both proceedings involve similar facts and witnesses, and it is unlikely evidence will be lost or memories will fade with the passage of time during a stay. Especially since it's basically a stay until September 12th. Additionally, the public interest weighs in favor of a stay because the public has an interest in ensuring that the criminal process is not subverted by ongoing civil cases. That cites Douglas versus United States, Northern District of California, 2006. Based on the foregoing, the LVMPD defendants have met their burden of establishing the circumstances in this case justify the court's exercise of its discretion to stay the instant case pending the resolution of the state criminal proceedings against Decastro. Heck suggests that a stay is appropriate here. If a stay is not granted, the defenses available to the LVMPD defendants may be wrongfully limited. If the court in the criminal action considers Decastro's factual allegations regarding the March 15th, 2023 incident, such findings may be binding in this court. Until the criminal proceedings are resolved, it is unclear whether certain defenses are available, such as a bar against some or all of Decastro's claims pursuant to Heck, or issue preclusion. Issue preclusion would be... So it's in this case, it would be a collateral estoppel type thing. It's, you know, if one court finds something, another court can't take up that same issue. So if Decastro, if Delete Lawz is found guilty of obstruction, meaning it was a lawful arrest, the issue of lawful arrest is precluded in this civil case because he can't claim unlawful arrest because that issue has already been decided. That's a very poor explanation of issue preclusion, but there you go. That's C. Wallace. See also Vivas versus City of Riverside, Central District of California, 2016, which says staying excessive force case where criminal prosecution for resisting arrest was pending. Here, Decastro faces charges of obstructing a public officer and resisting a public officer pursuant to NRS Section 197.190 and NRS Section 199.280.3, respectively. Accordingly, as the Ninth Circuit noted in Wallace, the question of whether Decastro's Section 1983 action is barred by Heck is more difficult to answer in this case, where Decastro is facing charges of resisting arrest or similar conduct arising from the same incident he is claiming excessive force. Additionally, Heck and Wallace favor the imposition of a stay because Decastro's criminal action and the instant case involve the same set of facts, and Decastro's ability to maintain some or all of his Section 1983 claims is contingent upon his receiving a favorable disposition of the subject criminal charges. Next, the Younger abstention requires this court stay the case. So the previous two was, these are optional, but the factors support a stay. Younger requires a stay. Even if this court determines a stay is not warranted under the former analysis, a stay is warranted under Younger. Here, Decastro's criminal case is ongoing and implicates the state of Nevada's important interest in ensuring the integrity of its criminal justice system. See Kelly versus Robinson, Supreme Court 1986, which says the state's interest in administering their criminal justice systems free from federal interference is one of the most powerful of the considerations that should influence a court in considering equitable types of relief. Indeed, Decastro may raise constitutional issues in the state proceeding. See Pennzoil versus Texaco, Supreme Court 1987, which says a federal court should assume that the state procedures will afford an adequate remedy in the absence of unambiguous authority to the contrary. In addition, Decastro is seeking damages in this civil action. Accordingly, it is clear that principles of judicial comity authorize the court to stay this action until Decastro's criminal proceedings have concluded. And comity is with a T, not comedy, and it basically means respecting the other court's power. That's not the exact definition, but that's basically it. Conclusion. Based on the foregoing, the LVMPD defendants respectfully request that the court stay this civil action during the pendency of the state court criminal proceedings, dated the 6th of July, 2023, Marquis Auerbach, signed Craig R. Anderson, and certificate of service. And then we have Exhibit A, which is the docket of the criminal case. And I was right. Bench trial on September 12th. Judicial Officer Ann E. Zimmerman. So, moving on, we have, frankly, this one's a little surprising to me, but in a way, maybe it's not. Because we all know he is terrified of discovery. So, plaintiff's non-opposition to defendant's motion to stay discovery. He's like, wait, you mean the case isn't going to be thrown out yet, so I don't lose, but I also am not subject to discovery yet? That's a win-win. Hooray. I mean, of course, non-opposition when, you know, I'm not a psychiatrist, I'm not a therapist, I'm a lawyer. And I finally did pay my extortionate bar fees, so I can officially say I'm a licensed attorney. But you know, I have a strong lay opinion that if Delete Lawz were to see a psychiatrist, there'd be quite a chance he'd be diagnosed as having oppositional defiance disorder. So just to see him say, yeah, I don't oppose, that shows you how much he's terrified of discovery, because he opposes everything. You tell him the sky is blue, and he's going to say, that's the blue sky flag, and that's tyranny, and blah. Whatever he can do to argue against it. So, but let's see what he says in it. Plaintiff Jose Decastro offers the following response to all defendants' motion to stay discovery at ECF number 32. Well, hang on. Let's go back up. Defendants, LVMPD, officers Torrey, Bork, Dingle, Sorensen, Sandoval, and Doolittle. What? Where's the state of Nevada in this motion? Where's the state of Nevada? I mean, he thinks he's. I know. At the beginning of the video, we discussed state sovereign immunity, but he still thinks at this point that the state of Nevada is a defendant. They didn't bring this motion. They haven't responded. They're, you know, they don't even go here. Yet this is all defendants' motion to stay discovery. So, in support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. Memorandum of points and authorities. Plaintiff has not analyzed the law stated in defendant's motion, but that law is likely misguided, as is the pattern of the defendants. Just say you agree. You're not opposing, just say you agree. I mean, I was going to do this at some point. I don't know that I was going to do it today. I don't know that I was going to do it today. I was probably going to do it for Floyd Wallace. But let's take a look at the Nevada rules of professional conduct. Let's see. I mean, he definitely. I realize this is tiny. This is teeny tiny. This isn't a good website for it. But if he were an attorney, boy, would he be breaking Rule 1.1. Competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. But let's see. Communication. That's client communication. Okay, transactions with persons other than clients. Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make false statements of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client unless disclosure is prohibited by Rule 1.6. Now, remember, not remember because I didn't say this yet, but these are the rules of professional conduct for lawyers. But where applicable, they also apply to pro se people. So, like the duty of competence, well, he's representing himself. He can be as incompetent as he wants. Client communications, he is the client if he thinks that he's communicated it. But in respect for rights of third persons, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. A lawyer who receives a document, that's about blah blah. Let's see. Hey, Rule 5.5 on authorized practice of law. We might have to get into that next time we discuss Floyd Wallace. Let's see. Okay, here it is. Maintaining the integrity of the profession. Misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. That doesn't matter. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to the administration of justice. State or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules. Knowingly assist a judge or judicial officer in conduct that is in violation of the rules. Okay, well, it doesn't really matter here, but I'm not seeing it on the fly. But there's going to be a rule of basically not being a dick, to put it bluntly. Civility. Here in Utah, I have to take 12 hours of continuing legal education. And at least one of those every year has to be professionalism. I haven't analyzed the law, but I'm sure it's wrong because they're always wrong. You want to get sanctioned, that's a good place to start. I mean, and plaintiff has not analyzed the quotation of plaintiff's facts from his amended complaint, but they are likely misstated, as also is the pattern of these defendants. I mean, talk about projection. However, unlike the defendants, when this plaintiff has no factual or legal basis to oppose the relief granted in a motion, he will not do that. So they're wrong, but I don't know why they're wrong, so I don't oppose. Ooh, he makes me mad. This court should grant defendant's motion to stay this civil action during the pendency of the state court criminal proceedings, if this court finds that it has been properly pled. Respectfully submitted, respectfully, Jose Decastro, pro se plaintiff. And apparently no certificate of service is needed on this one for some reason. And his civility, or lack thereof, I should say, like I said, we're going to need to have more discussion on that. But I do think that the Floyd Wallace case is the place to do that more in depth, because I really do think that one of them in that case is going to be sanctioned before it's all said and done, because like he's a mega dick in this one, but he's turned it up to 11 in Floyd Wallace because he's signing Floyd's name, so he can't be held accountable for incivility. He can't be sanctioned. If he crosses the line, it's Floyd's ass on the line. I mean, I realize that's kind of the story of Floyd's auditing life, because you know he's always the bullet bait, which is why I call him news now future statistic. But it's the case in the lawsuit as well. Floyd's signature on the bottom of the pleadings, he's in the crossfire if Delete Lawz, because we all assume Delete Lawz is the one writing the motions and filing them, and you know, has Floyd even seen any of them? I don't know. But his signature is the one that's copy pasted at the end of it, so he could have problems. Of course, if he does face sanctions, he could say, hey, I haven't submitted a single thing. This has been entirely Delete Lawz engaged in the unauthorized practice of law without my permission. Although that's kind of hard to claim since he was there at the courthouse when the complaint was filed, but everything else is, you know, he's off doing his passport bro stuff, isn't he? So either way, he could find himself in hot water very easily. So next we have, of course, the minute order on those motions. Well, that motion and the non-opposition. So minute order in chambers of the Honorable Magistrate Judge Elena J. Ucha on July 21st, 2023 by Judicial Assistant E. Santiago. Pending before the court is Las Vegas Metropolitan Police Department and the officers' motion to stay discovery. Plaintiff filed a non-opposition to the motion on July 19th. Accordingly, it is hereby ordered that the Las Vegas Metropolitan Police Department and the officers' motion to stay discovery is granted. It is further ordered that no later than 14 days after the court issues an order pertaining to the pending motion to dismiss, defendants must contact plaintiff for purposes of meeting to discuss a proposed discovery plan and scheduling order to be filed with the court. It is further ordered that no later than 21 days after the court issues its order resolving the motion to dismiss, a revised proposed discovery plan and scheduling order must be filed with the court. It is further ordered that if the parties cannot agree on a revised discovery plan and scheduling order, they must each file a proposed discovery plan and scheduling order no later than 21 days after the court issues its order resolving the motion to dismiss. So, yeah, so basically we've got to stay for discovery. Unfortunately, that hasn't stopped Delete Lawz from being a moron. But let's see why he's a moron. So we have the defendants, LVMPD, and the officers' answer to the plaintiff's first amended complaint. Because remember, they only did a partial motion to dismiss. So for the causes of action that they didn't move to dismiss, like battery, because, him saying they punched me in the nuts, that's enough to survive a motion to dismiss. It's still a disputed fact. They didn't admit to it like he tried to claim they did by not moving to dismiss in the 12b6. They didn't admit to it because the answer is where they specifically deny it. So even though they have a pending motion to dismiss, they had to at least do a partial answer. But so defendants, LVMPD, and the officers, by and through their attorneys of record, Markey Auerbach, hereby answer plaintiff's first amended complaint as follows. Introduction. These answering defendants deny the allegations contained in paragraphs 1 and 2 of plaintiff's first amended complaint. So remember, you've got to admit, deny, or like here, these answering defendants are without sufficient knowledge to form an opinion as to the truth of plaintiff's allegations contained in paragraphs 3, 5, 12, 14, 15, 16, and 17 of the plaintiff's first amended complaint, and therefore deny the remaining allegations. So it's basically, we don't know, so we're going to deny them because, if we don't know, we can't admit them. So, but you've got to do this with each and every allegation. And they've done so. And first cause of action. These answering defendants are without sufficient knowledge to form an opinion as to the truth of plaintiff's allegations contained in paragraph 48, and therefore deny. And they specifically deny 49, 50, and 51. So, and they continue through all of the causes of action. Usually an answer is, frankly, the most boring pleading because it's admit, deny, admit, until we get to the affirmative defenses, because you've got to assert the affirmative defenses in your answer. Otherwise, they're generally going to be waived. So, first affirmative defense. Plaintiff's suit fails to state a claim for relief as he failed to allege a violation of a right, privilege, or immunity secured by the United States Constitution or by the laws of the United States. Second affirmative defense. The officers had probable cause to arrest plaintiff. Third affirmative defense. The complained of acts of these answering defendants were justified and privileged under the circumstances. Fourth, at all times mentioned in plaintiff's first amended complaint, these answering defendants acted in good faith belief that their actions were legally justifiable. Fifth, the individual officers have qualified immunity from the actions alleged against them in plaintiff's complaint. Sixth, the Nevada Revised Statutes, Chapter 41, limits the damages that may be collectible against a political subdivision of the state of Nevada. Because LVMPD is a political subdivision of the state of Nevada. So there's a sovereign immunity claim there, but generally it's waived to a certain extent. But what they're saying here is, hey, even though we've waived some of our liability or some of our immunity, we'll allow you to sue us, to sue our political subdivisions. Sorry, not the state of Nevada. We will allow you to sue the political subdivisions of the state of Nevada, but only up to a certain limit. Other than that, you can get stuffed. So, seventh, plaintiff's first amended complaint concerns a discretionary function of the LVMPD defendants for which defendant LVMPD is immune pursuant to NRS 41.032. Ninth, the plaintiff's claims of constitutional violation, is unsupported in both fact and law, as plaintiff has not alleged sufficient basis from which a constitutional interest might arise in conjunction with the alleged actions. 10th, to the extent plaintiff's causes of action against the LVMPD defendants sound in negligence, no recovery can be predicated upon 42 U.S.C. Section 1983. 11th, any injuries allegedly sustained by plaintiff were the result of his own negligence and or actions. So this is basically, hey, you've got a duty here too. You've got a duty to mitigate your own harm. So basically, if your nuts were punched, it's because you were fighting back. You weren't standing still while they were searching you, so incidental contact became harder than was intended. It's the result of his own actions. So it's, even if you were punched in the nuts, our officers didn't mean to, but your nuts contacted his fist or his hand or whatever. 12th, plaintiff cannot recover punitive or exemplary damages because plaintiff has failed to plead and cannot establish facts sufficient to support allegations of malice, oppression, or fraud. Plaintiff is not entitled to recover punitive or exemplary damages herein under any of the claims of relief alleged, as none of the LVMPD defendants, supervisors, directors, or managing agents committed the alleged malicious, fraudulent, or oppressive acts authorized to ratify such wrongful conduct, or had advanced knowledge of the unfitness of any employees who allegedly committed the acts and did not employ such persons with conscious disregard for the higher safety of others. 13th, the claims and each of them, so each and every one of the claims, are barred by plaintiff's failure to plead those claims with particularity. 14th, these answering defendants have not been negligent and have not breached their duty to properly supervise the conduct of its employees with whom plaintiff interacted. So that's basically supervisory liability for, is it Doolittle that's the supervisor? And LVMPD itself. Let's see. 15th, These answering defendants reserve the right to amend these affirmative defenses as discovery unfolds and new information is discovered. Wherefore, these answering defendants pray for judgment as follows. 1. That plaintiff takes nothing by virtue of his first amended complaint on file herein, that the same be dismissed with prejudice. 2. For an award of reasonable attorney fees and costs of suit incurred in the defense of this action. I mean, let's face it, that there's almost no chance of the state recovering legal fees, but it would be nice if Delete Lawz finally saw more than $402 of consequence for his frivolous suits. Although I guess I already closed it, but there was the $225.70 wasted serving the state of Nevada. And 3, for such other and further relief as this court may deem just and proper in the premises. Dated the 6th day of July, 2023, by Marky Auerbach, signed by Craig R. Anderson, and served by ECF and by first class mail, because Delete Lawz, you know, as I christened him, I think in the last video or maybe the one before, he is Jose Maria Antoinette, because he wants to have his cake and eat it too. I realize the official quote is, well, the quote as it's known is "let them eat cake," but I think it's officially like the official translation would be something to the effect of, if they have no bread, let them eat brioche, which is basically a bread with lots of butter in the batter and the dough. But he wants to have his cake and eat it too. So Jose Maria Antoinette. So because he wants to have his cake and eat it too, they served him by PCF because he asked for access and was granted. He never followed through. So they're like, you know what? We're going to do it both ways. That way, he can't throw a hissy fit either way. Because if they didn't serve him by ECF and they just served him by first class mail, he'd object. You didn't serve me by ECF, so it's not a valid service. So, bleh. So, next, from the Utah equivalent of the 4th of July, the 24th of July, also known as Pioneer Day here in Utah, and to non-Mormons as Pie and Beer Day, we have plaintiff's motion to partially strike defendant's answer and to have responses in defendant's answer deemed admitted. And this is, I realize I've actually managed to get through multiple documents relatively quickly. This is where it ends, because this is where we get Delete Lawz in full-on Delete Lawz mode. I haven't fully read this motion, but it's going to be a doozy. When you have this moron claiming that the lawyers are morons and don't know how, they don't know the procedure. I'm the expert. I'm the constitutional law expert. I'm the 20-year constitutional law scholar. That's never heard of the 11th Amendment. Yeah, it sounds legit to me. And let's see. And it sounds so legit to me that I've decided, even though I am behind, I'm going to save this because I'm just I'm not ready. I've got to start fresh for this level of nonsense. So I can't do it. I can't do it. I just can't. So, and my water's almost gone, so I'm just not going to make it through. So, with that, like I said, I'm going to save this. I will definitely not leave you hanging for 2 weeks this time. I will be back very soon to either go through this or stay in Vegas and do some of the backlog of Floyd Wallace, or even go up to Idaho and do some of the Scofield stuff. Speaking of which, I don't have it pulled up, but I'll link it down below. Please continue supporting Professor Scofield's Gofundme. It's a good cause, and we've gotten good entertainment from discussing the case and lots of frustration because of Ashley Guillard's nonsense. But, you know, we want Professor Scofield to be able to take it to the end, so please support her in doing that. And who knows, I may even do a video or two of sovereign citizen arrest in the meantime. But yeah, so that's where I'm going to leave it today. I will see you very soon. Please like, share, subscribe, do all the fun YouTube-y stuff, and I will see you very soon. Thanks for joining me. Bye-bye.